We're going to begin now with panel 2, addressing what are the success factors for core international crimes prosecutions at the national level, looking at key cases and best practices, and we will be welcoming one participant from Argentina, Mr. Quintana, who will be joining us shortly on the screen, and our moderator is Dr. Anja Neistad, who is the legal director of the Docket Initiative from the Clooney Foundation for Justice. With that, I will remind you to silence your mobiles if they are talkative at the moment, and I will pass it over to Dr. Neistad. Thank you very much.
Thank you very much. I think what we're going to do is follow a little bit the structure of the previous panels. So we will open it to some opening remarks and then move on to questions both from me and from the audience. I think there have been already quite a few subjects and issues raised in the keynote speeches and the previous panels that we probably will try to build on. But without further delay, I would like to introduce our first panelist, Eva Vukucic. Eva is Assistant Professor of International History at Utrecht University in the Netherlands. She holds a PhD from the History Department, where she defended her dissertation on paramilitaries during the breakup of Yugoslavia. She was affiliated with NIOD Institute for War, Holocaust and Genocide Studies in Amsterdam. And she also worked for the Sense Agency in The Hague, covering trials at ICTY. And before that, and I think that's a little bit what her remarks will start with, a focus on, she was also an analyst and researcher at the Special War Crimes Department of the State Prosecutor's Office in Sarajevo. Eva, over to you.
Thank you very much, Anja, and it's really a joy and a pleasure to be here. I feel really honored. I feel honored also because my former boss, David Schwendeman, is here, and he was at the head of our office when I worked in Sarajevo, and he's the best boss that I've ever had. So it's such a joy to see him, through the years. Of course, I'm not a 20-something-year-old kid anymore, so it's nice to kind of catch up every couple of years and be able to exchange some experiences when it comes to the things that we're all concerned with. So I want to begin, as Anja has suggested, by kind of taking the big picture into account, in the sense that it's, I would argue, really an unprecedented moment when it comes to mobilization of various kinds of actors when it comes to justice efforts in Ukraine specifically. And I think it's really a good time to try to assess or reassess where we are and where we're going. And I think some of the conversations this morning and yesterday, of course, were also geared towards that. I think the big picture is also one of ebb and flow, where developments, kind of surge and things change, and it's kind of an ever-changing sort of situation. But now I think we're really finding ourselves in an unprecedented moment where it's a good time to assess some of the very fundamental things about what we're trying to do. So I come to this topic as a historian, so I'm in a minority here, so please take my accounts with that in mind. And I'm also an academic, a genocide scholar, but one with practitioner's experience, of course, in Bosnia and Herzegovina. I'm going to refer to it either by Bosnia or BIH, just to shorten it for the purposes of this panel. So this was a domestic institution that had, of course, international staff and some kind of practices and cooperations, but it was a domestic institution, and it's a domestic institution that still functions and prosecutes in Bosnia and Herzegovina. And I was there in the late 2000s. So these are going to be comments that are basically linking or sort of looking back to Bosnia and trying to think what are some lessons or some things that we can take from those experiences, the positive and the negative, looking at the conflict in Ukraine. So I'm going to start by briefly talking about some similarities and differences between these two contexts, and then address what I think are three sort of areas of concern that I would pay particular attention to. So the similarities and differences, and this is of course going to be really simplified because of the constraints of time, concern Bosnia and Ukraine, and how, first of all, the conflicts are taking place in their territory. So my comments are not really going to be about universal jurisdiction. These are going to be domestic institutions trying to work with a mountain of alleged crimes, or a mountain of suspects. War was ongoing when the ICTY was established, of course, so in some ways it's also similar, you know, to the war in the former Yugoslavia and the establishment of the ICTY back in 1993. So first, I think that something that we need to keep in mind as a similarity is the fact that there's going to be thousands of potential suspects, thousands and thousands, and the Ukrainian prosecutor already has made some sort of remarks to that effect. So I think it's really important to just kind of acknowledge that no system in the world will be able to deal with all of that, which will then also lead to some comments later on about the need to prioritize, to have really clear guidance as to how to select investigations and cases going forward, and the ability to explain that to the public. So, you know, no system can manage all of these investigations and prosecutions successfully. There will be a need to prioritize, and I think as well, both countries have some weaknesses when it comes to just effectiveness of judiciary, you know, expertise, even though, of course, a lot of training has been going on in Ukraine for years, since 2014, I think, especially. The differences, I think, are in the attention and the efforts to investigate. Of course, there was a lot of focus on Bosnia and Herzegovina as well, but what we're seeing now in Ukraine with the multiplicity of actors is really unprecedented. Ukraine, of course, has no ad hoc tribunal, and it won't as things stand. So it's really, it really in that regard is kind of a different sort of a context. And finally, another difference is that Russian soldiers, be it grassroots level or higher up, are for the most part not going to be easily available. That is the difference, I think, as well with Bosnia and Herzegovina, where some suspects weren't available, but of course, at the end of the day, many of them were living in, you know, in the country. So I think this is going to be a substantial challenge going forward. Although I have read this morning, apparently the first trial in Ukraine by the Ukrainian judiciary has started this morning of a 21-year-old Russian soldier, I think, charged with the murder of one civilian. I think I'm getting the facts correctly here. Let me just now move to the three bits that I think need really attention, particular attention, looking back at Bosnia and Herzegovina and the things that I think haven't worked or haven't worked sufficiently or sort of to what we were hoping for. I would say, of course, all of this, and we're all aware of this, depends on politics, not least in Russia and Ukraine, but also elsewhere. But at the same time, and prosecutors here will know this, as you know, that really there is a need to try to depoliticize it as much as possible, and try to work with the intent that fighting impunity really requires a long-term commitment. We're talking 10, 20, 30, 40 years, who knows? So I think going forward, it's something that we really need to keep in mind. And coordination has been stressed several times, of course, and I think the role of Eurojust, of course, has been stressed as well. But I'm just wondering, scaling up, thinking about potentially hundreds of cases in different jurisdictions in different states with Ukraine as well, and the ICC. I just think if we scale it up, I think this is really, really going to be an enormous challenge to you know, and to then have this commitment for years and potentially decades to come. I think there's also a need, of course, to build expertise continuously, but then at some point, as we saw in Bosnia, you need to stop trainings and just let people do their work, because to a certain extent in Bosnia, you had a feeling that there was some kind of training all the time, and I'm not sure that at all points all of these are necessary. And this brings me also to the issue of selection and prioritization criteria, and I think David can speak to this probably as well, much more given his position at the time. But I think they need to be clearly defined in some consultation with the public and the victims as well, and then they need to be explained and explained endlessly, and not just conduct these investigations behind some closed doors and then never, you know, explaining, because there's going to be people who are frustrated. Why is my municipality not in that indictment? Why is my particular victimization in place X not part of this case? Because of course not all of it can be, it's just not possible. So the need to communicate continuously and from the start, I think, is really crucial. There's also going to be a need to, explain investigations against Ukrainian nationals, because there's going to be cases where we also need to investigate those kinds of cases. This is not false equivalencies. I think it's just in conflicts, war crimes are committed by various actors on various sides. Doesn't mean that they all do it to the same extent, but like we've seen in Bosnia and Herzegovina as well, There's investigations against, nationals or members of communities where the response is maybe not favorable. But this is also something that we need to, I think, take into account and really ask Ukrainians and Ukrainian citizens, what do they want? To not have this sense of a process imposed from outside, but to try to conduct consultations and to see what Ukrainians want. It also now moved to the second question of outreach, which has also appeared before. And as I already said, manage expectations. We hear this a lot in The Hague, but this is already really, I think, in the last 10, 15 years, maybe really become like a topic at the forefront of the debate. And it needs to be clearly said that, whatever is done, even if it's done successfully, it's probably going to be a drop in the bucket. It's probably going to be a couple of dozen, a couple of hundred, as opposed to 5,000 people. And I think it's important to acknowledge that. And to manage expectations, not only with the victim communities or the society situation in the country, however we want to define it, but also more broadly in our own community of practitioners, academics. And sometimes you hear things like, we need to have the same version of the past, or something along those lines was a thing in Bosnia. And now as a professional historian, it makes me think about cases like the US Civil War. This was 160 years ago, and there's no established narrative about what had happened. I don't think it's realistic to expect everyone agreeing to a certain narrative of the story. And to a certain extent, history is a dispute. That's what I do all day, disagree with other people about historical events, and what my colleagues do as well. So there's an importance to agree on the basic facts of what had happened, but not necessarily share all the narratives kind of, to the level of detail, I suppose. We can discuss reconciliation later. It's really remarkable that the word hasn't even been said in a day and a half that we're here. I think it speaks a little bit to the movement of our own community about what we expect from this process. So maybe in Q&A there's going to be time. So just 2 or 3 more points and then I'll be done. Language. I am super interested in discussions about recordings and video and audio and transcripts. I wrote my PhD on ICTY evidence. I want to applaud the ICTY and the ICTR as well, for having the database where you can access evidence as a researcher and write books about it. So I think even if the prosecutors, of course, don't have the immediate intention to release any of it, I think it's really important to try to record it for the future, because there's going to be a time when there's going to be less controversy maybe, or less danger for witnesses, and if you don't record it, there's never an opportunity to go back. And to make this available in the languages of the affected communities, so Russian, Ukrainian, BCS, what we called it at the ICTY, so that people can study it and research it. And I think other international and domestic institutions in the judiciary should try to make as much as possible available. I know that not everything can be, and that's fine because of security, privacy, but as much as we can, with this idea of transparency in mind as a guiding principle. This brings me to legacy and archives, to try to incorporate the idea that there's going to be something after trials, and to make it conscious from the get-go, not like I think at the ICTY kind of happened after 15 years of it already existing. So to try to incorporate an idea of legacy and archives from the beginning into this story, and to try to think of what is this for beyond the conviction or the acquittal, to try to see what are broader societal sort of benefits. Like Mr. Brody was, of course, making the point that, of course, it's about the prosecution of the individual for a certain crime, but I would argue there's also more to it, as many other would say as well. So just to conclude, of course, it would be a good idea, I think, for us to take this moment to identify or try to more explicitly discuss what constitutes success and failure when it comes to international prosecutions. I think it's one thing to discuss it in abstract, because in 10 years' time we're going to be one to talk about, so what did we do, how did it go when it comes to the investigations in Ukraine, and we should have some benchmarks to try to assess how things are going. So I'll leave it at that for the moment, and then I'm sure in the discussion we'll have plenty of opportunity to exchange some thoughts. So thank you very much.
Thank you very much. Eva, thank you very much. First of all, I think it is very useful to step back. We're all very much in the moment, but I think it was very helpful, and we'll definitely come back to some of the points that you raised, including this last point about potential reverse engineering of cases to see what works and what hasn't, and learning from failures as much as learning from successes. But let me turn for now for the opening remarks to our second speaker, Joren Stad. Joren has a long career in practicing both the law of armed conflict and Dutch criminal and military law. He currently holds the position of coordinating public prosecutor for core international crimes at the Dutch National Public Prosecutor's Office. He leads investigations and prosecutes cases before the Core International Crimes Chamber at the District Court of The Hague. He is also a steering board member of the European Network for Investigation and Prosecution of Genocide, Crimes Against Humanity and War Crimes, Genocide Network, and prior to his current position, he held the position of public prosecutor for military crimes, and while in the military, he spent time with missions in Macedonia, Iraq, Afghanistan, and so on. So I will then, all of the full biographies, I'm shortening them a little bit, they're all available in the brochure, but for the sake of time, Joren, the floor is yours.
Thank you very much, and I'm also honored and very pleased to be here and to be able to share my views with you. And those views are from a practitioner's point of view and also obviously the Dutch perspective. And when we look at the main question for our panel, what are the success factors for core international crimes to be prosecuted at national level? I distinguish three factors. Organizational setup, the requirements for that, international cooperation, and governmental approach, the CIC chain cooperation within the Netherlands. To start off with the organizational requirements, when you look at the Netherlands, we are, with a couple of other states, very happy and pleased with a luxury position that we have a specialized prosecutions unit in place. We are with 8 professionals, 3 of them are prosecutors, so I have 2 colleagues. We have a CIC legal expert. She provides us with in-depth legal scientific analysis and advice during our investigations and also during trial. We have a policy advisor. We also have a cultural anthropologist, and the other positions are of our legal assistants who help us carry out our work. That's on the prosecution side. On the policy side, who actually run the investigations themselves, we are happy to have a specialized unit of 43 personnel. And besides detectives, junior and senior, we also have specialists on OSINT, on geolocation. We have several analysts for data analysis. And what is also very a big advantage for the Netherlands is that we have these funding of the police unit that is specific own funding, and this cannot be changed whenever another major incident might happen, and the police will look at our team of international crimes unit at the police level and ask for some assistance. They probably will get the answer no. You have to get them somewhere else, because these are dedicated to investigate and help the prosecutions of core international crimes. So that's something very unique and well organized, and there's always enough to want, and we surely need more personnel, but this is what is in place and helps us for several years of investigating and prosecuting these types of offenses. And I forgot to mention what is actually the basis, which is the CIC legislation. You need to have that in place. Not all countries have that in place properly, and in the Netherlands we have what we call secondary universal jurisdiction. So it's not a general universal jurisdiction. It's limited to 3 categories: the perpetrator, is on Dutch territory, or the perpetrator has the Dutch nationality, or the victim has the Dutch nationality. In those instances, we have jurisdiction, and we start or are able to exercise that jurisdiction. Now, that sounds all fantastic in the Netherlands, and although I'm reasonably happy, we do still have challenges. And when you look at what other countries are facing is a lack, I believe, of political will, which is, again, also needed for funding, and that is very crucial. If you want to organize, not necessarily similar to the Netherlands, but within your own state, something similar, the political will to allocate resources and money on a permanent basis, that is absolutely essential. Otherwise, as I just mentioned, if there's a big incident or another type of crime that rises and public pressure is on the politicians and those in government, they tend to look at specialized units and want to cannibalize them, so to speak. And they're having regulations in place for the organization and funding that helps us fend that off. And the other big challenge is what in every country is similar, is that analysts are the most scarce asset. Turning to the second factor, the international cooperation. Personally, to me, that's a given. I started my career in the military, and Netherlands is a small military. We operate within NATO usually, or in international coalitions. So you always have to work in an international environment. And when you prosecute or investigate and prosecute core international crimes, that's similar. So we work closely with prosecution services in other countries. Also the police units cooperate very closely. We have obviously Eurojust and Europol linkages, also with the OTP. And another important part, and I'm sorry to have missed yesterday, but I'm pretty sure the NGOs would have been mentioned there, and as I have seen on the agenda, they will be covered, I believe, next or otherwise tomorrow. The NGOs play also a very important role to cooperate with. They are very helpful in documenting crimes, and they usually have some more possibilities to work abroad and to access communities already where they've been working for quite a long time and build those trust relationships. But what are those challenges? When I look at the Netherlands at the moment, we have challenges in the exchange and sharing of information between the various types of organizations, and questions in court about some quality of NGO reporting. So when we cooperate closely, for instance, with the NGOs, I had a case that I prosecuted myself last year, and we had a report from an NGO that we put in the case file, and it was very helpful for the contextual understanding, but it also had a part where it identified the perpetrator, and the way that they written the report and the way that they carried out the identification by people that they spoke to, that was very unclear, and we had to go to the investigating judge prior to going to the trial itself several times, and it took many hours of interviewing the writer of the report, who didn't carry out the investigation themselves. And in the end, the court decided that for the identification of the suspect, it wasn't able to, or they didn't say it was inadmissible, but the result was the same. And that made us think on how to communicate more closely and better with the NGOs in order to avoid these kind of issues. And in another case, to point to the use of, for instance, geolocation, also last year, a investigation that was put to trial was a Syrian colonel was executed on the river banks, and we used geolocation. It was filmed by two persons, so you could actually see the execution and also the walk that this officer had to go through before he reached the end of the river banks, and was filled with bullets. The police had, with their geolocation, were able to reconstruct the moment that the videos started and provide a landscape view of the route that those men, including the perpetrator, but also the victim, had to go through, and that provided the court with a better understanding of what happened, rather than having some footage. Of course, you can see what happens, but it provides you better understanding of the environment where it happened, and also the defendant claimed that first of all it wasn't him. Then we found the other video where he was fully in view, so there went his argument that it wasn't him. But also the actions that he carried out, and in the meantime, when they went up to that riverbank, that helped the court assess the written documents more better. And why is this important? In the Netherlands, we don't use witnesses in court that much. We tend to interview the witnesses prior to going to court. So we process, we use trial basically on paper. So reading two-dimensional things in paper is what we usually do, and this geolocating and putting it on video made it so much more comprehensible. And lastly, the third factor, that's the governmental approach. In the Netherlands, we have what we call core international crimes chain approach. We call it the barrier model. There are several services that are involved in this approach: the Immigration Service, Ministry of Foreign Affairs, Ministry of Justice and Security, Repatriation and Departure Service, my office obviously, and the police. And we cooperate together. We provide each other with advice, information on basically expelling or extraditing those that try to use the Netherlands as a safe haven, and they're denied. And if that's not possible, then we see whether or not we can now start an investigation and prosecute. What are the challenges in that cooperation? Similarly, the exchange of and sharing of information, that seems to be so difficult with the EU General Data Protection Regulation. That's at the moment something that we are looking into in order to be able to provide each other with the best information. We do need to work together, because all these services have some information and take action that might inflict or cause a reaction with another service. So you do need to coordinate that. And lastly, as an example of the barrier model, also last year I went to trial for an extradition procedure for a person to Rwanda. He was provided with a 1F status. I see people nodding. Rwanda requested the extradition. That was granted by the district court, which I tried there. And the decision was also upheld by the Supreme Court. And then the procedure against the Immigration Service to revoke the asylum permit is at the moment not yet final. And here comes the governmental coordination. Once the last procedure is also finished, we need to make arrangements for the extradition. And sometimes during the extradition, there are issues that need to be discussed within the CIC chain cooperation. Very practical from medicine, very practical from requirements that are made by our minister to, for instance, Rwanda, for them to be able to receive this individual to be tried there. There are a lot of requirements made, and we do need to discuss these and be aware of those. And once there are problems with that, it helps within this CIC chain cooperation to get the heads together and sort those out. So that doesn't mean that everything works well, but not having a forum where you can discuss this policy and also these case issues makes life very much more difficult, I would say. So that would leave me with the end of my introduction remarks.
And thank you so much, and thank you for some very specific examples. I think it's always great to have both kind of the broad overview and the specific examples, and definitely would like to pick up on your point on the role, the value, and the challenges of civil society actors, private actors, in the types of prosecutions and investigations that you and your colleagues in other countries run. But before we do that, I'm going to turn to our third panelist, Thomas Quintana, who is a lawyer from Argentina working in the field of criminal law, human rights, and public interest, representing NGOs and other groups in various cases, including child abduction by military regimes, sexual abuse by members of the church, and business criminal liability for human rights abuses. He's currently the attorney on a universal jurisdiction case on the abuses against Rohingyas. He served as the special rapporteur on the situation of human rights in Myanmar from 2008 to 2014, and prior to that as consultant to the Office of the High Commissioner for Human Rights in Bolivia. And I believe, at least I'm very much looking forward to Thomas speaking about the current case in Argentina, which I think all of us are watching with a lot of interest, because it is quite unusual still to have such cases. Thomas, the floor is yours.
Thank you very much, Anya. And hello to everybody. Apologies for not being there. I would really like to be in Nuremberg, but it wasn't really possible. But here I am to share with you our experience on this universal jurisdiction case that's taking place here in Argentina, in Buenos Aires. So the title of this panel is Success Factors for Core International Crimes Prosecutions at the National Level, Key Cases and Best Practices. So we are really just starting with this case. So to speak about success factors, we will have to wait and see at some point, to be honest. And at the same time, we are trying to use the best practices being used in the past in this kind of case. So let me just make three brief points about the case, and then of course I will be ready to exchange with you, your views and your opinions, and kind of respond questions as well. First, let me address the issue of how the courts here in Argentina accepted universal jurisdiction, at least in this case. So we filed a complaint in 2019 based on the principle of universal jurisdiction. In Argentina, there is no regulation, legal regulation about this principle. We invoke the international law, which is contemplated in our constitution, to claim that universal jurisdiction needs to be applied by courts. And that's the simple argument. That's what happened. But there is no specific regulation, meaning that and there is I would say we have a general application of this principle, because we do not require to have either the perpetrator or the victim being a national of Argentina at all. So basically the principle applies in a purity standard, let's say. And this is what we did. So we have a Rohingya organization who decided to try the Argentinian courts. We also had, and this is very important, we still have 6 individuals, 6 Rohingya individuals. In this case are 6 women who are living in the refugee camp in Cox's Bazar in Bangladesh, who also joined this Rohingya organization in their individual capacity, claiming universal jurisdiction in Argentinian courts. What happened? At first instance, the court said, this is already being investigated at the prosecutor's office of the International Criminal Court. So we are not going to do anything. You know, this will complicate principles, international principles, and non-bis in idem, and other kind of principles. We cannot proceed. That was the first argument to dismiss the case. Second argument, and this second argument showed that the court was not really understanding the dimension of the problem in Myanmar, because they argued that at some point in Myanmar, the system itself and the rule of law in Myanmar will allow in the future for, you know, impartial and independent investigations to take place. That was the second argument, you know, basically the principle of complementarity. They say, let's allow Myanmar first to deal with these crimes. And we are talking about genocide, just to make it clear. This is what was the core of the complaint, you know, the genocide against the Rohingya. And the last argument, which was also an argument that we didn't accept, is that Argentina and Myanmar has no cultural connection, has no connection in terms of immigration, or any kind of social connection. So these were the main three arguments on this first decision from the Argentinian judiciary to dismiss the case. We started to respond to that, and we engaged a lot with the Prosecutor's Office of the Icc, who played a very important role in understanding the challenge and the importance of the initiative from these Rohingyas people seeking justice. And they supported the case, and they responded to Buenos Aires. From The Hague, they sent a communication explaining what was being investigated in The Hague, which basically was not exactly genocide, but some other international crimes. And they say that they support all efforts at the international or at the national level towards seeking justice based on the principle of complementarity. So that communication from The Hague to Buenos Aires was very important in terms of really giving the case what it needed, you know. And then we filed an appeal. We went to the appeal court. We presented our arguments. We explained that it was not really possible in Myanmar to hold, you know, independent and impartial investigations, and we rejected, you know, the last argument because, of course, especially when we speak about international crimes, we know that we cannot accept cultural relativism, you know, at all. So basically contradicts the essence of the principle of universal jurisdiction. That's why we are seeking universal jurisdiction, because we don't think that we need to what is required is any connection, cultural or any kind of connection between the two states. So the decision from the appeal court was in our favor, and the appeal court decided and instructed the investigative judge to launch the investigation about the genocide of Rohingya in Myanmar in Rakhine State. Okay, I will stop there. There are a lot of issues there because we don't have in Argentina a specific governmental body, or not even in the judiciary, who deals with universal jurisdiction cases, you know, who has the expertise, who has a team, resources. We don't have that. You just have, you know, the designated judge and the designated prosecutor, period, and you have to deal with them. And then we have the issue of what is the government of Argentina's stance on the principle of universal jurisdictions, because the court asked the executive branch what was their position about it, you know, trying to cover, you know, the political side of universal jurisdiction. I stopped anyway there on this first element. I will jump into the second one, which is what's it mean to launch an investigation of the genocide of the Rohingya in Myanmar? And the other panelists were talking about that. Of course, I mean, what are you going to investigate? What exactly are you going to investigate? You know, this is a litigation. For us practitioners, those who do litigation, we know how it is. You know, you need to get started and decide how to start and where to start. And you know, are you going to select, you know, a group of victims? Are you going to prioritize, you know, certain locations? What are you going to do? Those are very difficult questions that we're facing now. And when I say we are facing, let me just give you one concrete information in terms of the criminal procedure in Argentina. The victims can become, in the criminal investigation, can become, let me just mention, define it as particular prosecutors, private prosecutors, meaning that you have the right to present evidence, you have the right to cross-examine witnesses, you have the right to present analysis of the evidence, and you have an active role, and this is what we are doing actually, basically pushing the case constantly every day. This is the role that the Rohingya organization and these 6 Rohingya individuals, these 6 women have in this fight in Argentina, this very important role, because they have a strong voice to push and to define the investigation. This is the second element, you know, and we are now actually trying to show the court where to go in terms of what to investigate. And we are, of course, narrowing the scope of the investigation because the genocide took place in Rakhine State, which is a huge province in Myanmar, and all over, especially in the northern of Rakhine State, in Mongdo, Butidong townships, and all the villages around that. So this is the second element, and there are a lot of questions there about. We can discuss further about it. The role of the NGOs, the reporting of the NGOs, what is the use? What is the relevance of the reporting of the NGO community? You know, and in addition to that. And this is an element that I missed at the beginning, and I will take 5 more minutes, Anya, if I may. We have, like in Syria, in Myanmar, we have the independent investigative mechanisms for Myanmar. You know, this is a mechanism established by the United Nations after the fact-finding missions, the fact-finding reports, a body that currently exists and that has the mandate to basically collect evidence, play as a repository of evidence, but then the main core of the mandate is to share the evidence with those, you know, jurisdictions who are investigating the genocide. So it's let me share with you later how that is working out, you know, between us, between the mechanism and the Argentinian court. You know, we are pushing for the system to work all together, because what is important for this universal jurisdiction case in Argentina, there are a number of factors, but one of the factors is that we believe that this case in Argentina is part of the overall strategy of the United Nations towards seeking justice for the Rohingya. You know, it's not a random or isolated case. It's basically part of the structure because the mechanism exists, the UN mechanisms exist, because the fact-finding mission called for the universal jurisdiction, recommended countries to use universal jurisdiction, because the Human Rights Council resolutions with regards to Myanmar, mention constantly national jurisdiction and even universal jurisdiction in their resolution. So that's very important for the case itself. So I stopped here on this second element, and the last element, which is, and this has been discussed by the previous panelists, what is the role of the victims and the people itself, in these cases? And definitely what is very important in this case, at least in Argentina, is that the Rohingyas themselves, who are a community that I know very well because I have been in Rakhine State 4 times, and I know very well what is their plight, but also what are their difficulties in terms of a community to basically get together and organize themselves and to define a strategy on how to seek justice. And that's why we believe that in this case in Argentina, it is very important that they have a voice. And this is something that I will share with you. It's not confidential, but it's something that we are keeping for the time being, among us, because it's a difficult endeavor. But we are planning to bring these 6 women who are living in these households in the refugee camp in Cox's Bazar in Bangladesh. We are planning to bring these women to Argentina because they want to come to Buenos Aires. They want to do this journey all over the world to have the chance to be in front of an impartial and independent tribunal, a court of law, and explain what happened to them and claim for justice. So this is, I would say, for us, if this happens, and this is what we are doing, this is definitely a success factor of this judicial proceeding in Argentina, because we hope that at some point we will get to the suspects and the perpetrators, but the whole process is critical for the plight of justice, to continue to raise the justice accountability agenda for genocide of the Rohingya. It's important to empower the victims, and in this case especially, we are talking about women, Rohingya women, who had a very particular role to play in the Rohingya community. And we expect and we hope that this will give them, the Rohingya women, the necessary instruments to, basically empower themselves. And they are definitely courage individuals who want to seek justice, even though this file and this proceeding is taking place in the other part of the world. So I will conclude there. Thanks.
Thomas, thank you very much. First of all, I think it's a very interesting insight, and I'm sure there'll be more questions about kind of both the substance and the process of how it unrolls, because it is different from many of the European jurisdictions which have much more restrictive UJ regimes. But I also just want to thank you for bringing up again this issue of the agency of the survivors, and with many thanks to previous speakers who also raised that, because obviously from where we stand, that's also such a critical element in the success, not just of an individual case, but of the whole project of international justice. So I'm glad that it's becoming kind of one of the prominent themes during this day. If you don't mind, I'm going to abuse my role as a moderator and start with the first couple of questions, but then we do have a time to open it for questions and comments from the audience. So I would like to pick up on the theme of civil society, private actors, participation in proceedings. You already started mentioning, I think very helpfully, both the value that they bring to your work, but also the challenges that it creates. And obviously, Thomas, you just gave us an example of the case that would not have happened in Argentina, quite simply, if it weren't for civil society organizations. I don't know even to what extent you can comment on the role role of NGOs, but I think a lot of the documentation back then was done by NGO actors. And so I just wanted to hear a little bit more from you on, I think we are at the stage where it's a given, it's a reality, right? We're no longer discussing whether private actors play a role in these investigations, but we're still at the stage where there are lots of uncertainties for both us as NGOs and the prosecutors, the investigators in different jurisdictions. Each of these jurisdictions have different ways of engaging with NGOs depending on what type of jurisdiction it is. So maybe a few words from the panelists first, but also, quite frankly, it's such an intimate setting that I would very much like to hear comments from the audience as well, because I think from different ends, all of you had experiences with that. Eva, would you like to start, please?
Sure, I can start. Thank you. I think it's a really important question more generally, but also specifically as it applies to Ukraine. I've been following the developments there quite closely, and with friends and colleagues we've been discussing this. I think, first of all, I have to start with this acknowledgement that, of course, everyone is aware of, is that civil society and NGOs are crucial, both at the documenting stage, but also as advocates, as drivers of this process. So I want to acknowledge that to start with. But I think going back to the word that Karim Khan used yesterday, which is of a stampede now in Ukraine, which I think is a real danger, and having worked at the prosecutor's office in Bosnia as well, and I think practitioners will be aware of the challenges and difficulties and even, problems that come from having too many statements taken, or having statements taken by people who are not necessarily trained in the, in sort of the specifics. I think a lot of organizations are, of course, driven by the desire to do good, as naturally they are. But I think it's a really technical, it's a really technical thing to do, and I'm not sure that there should be this many actors kind of interviewing almost as people come off buses in such a disorganized way. I think it may be doing more harm than good. And I'm just throwing this idea out there as well. Potentially, there could be a consideration of some kind of certification process by which an NGO would go through a certain process that the community would decide these are some of the things in terms of, quality control, in terms of standards that we can agree upon, that an NGO could go through a certain process and then say, we indeed are in some way, sort of trained and have the capacity and the ability to do that. Because, of course, prosecutors lean onto, of course, and some even start from these kinds of materials to even begin the investigations. But I think there should be more order to it, and more intent. And as we were talking about it yesterday as well, I think it's also something that is donor-driven sometimes, taking statements, documenting, it's the word of the day, let's all do it. But maybe there's something else less, sexy sounding or whatever, that you can, bring real value to people's lives and assist people who are fleeing conflict that is not documentation and is not statement taking. So just a consideration of maybe there is a place for some kind of a process by which there would be order, so to say, in this endeavor. Thank you.
Thank you, Eva, and I couldn't agree more. I do not have a solution. I don't know how we can stop the stampede. I think this is, I wouldn't use that word because I think people do mean well, but how to stop it. I think there is an increasingly a certain level of self-regulation in the NGO community, but it's not sufficient. How to impose that would be very, very difficult. I think increasingly there are NGOs, including ourselves, that do not take detailed witness statements for exact those reasons, right? We identify them and hand them over to investigators and prosecutors. But there are others whose main purpose is public exposure, and they will take these statements because that's what they think is what they bring to the table. So I kind of acknowledge the problem, not sure if there are solutions. Joran.
I wholeheartedly second the comments that you made, Iva. For us as a prosecution side and also the police units, it is I'm usually well known for my bluntness, so pardon me. It's a jungle of NGOs, which makes it difficult for us to identify the most professional, the most experienced in a field, and it takes time to understand that. And time is something that you would like to limit to the things that you really need to contemplate about. And when you are able to identify NGOs in certain conflict areas that you want to investigate and already know upfront whom to contact, and other colleagues have positive experiences with, both during the investigation and what happens during trial. That really helps us, and that makes us able to be more expeditious in our investigation. That's something that that we really would like to see, and this is also something that we've discussed within the Genocide Network. Could there be some sort of atlas where all the NGOs register themselves, have got an expertise in this area and from that period, and what have you. That would make it so much more easy for us to find the proper NGO. And the second point I would like to make is regarding also what you mentioned, is the somewhat fear of NGOs providing evidence. We would preferably would like to work with NGOs that would be able to put us into contact with people that they've identified that might be victims or witnesses that are willing to talk to us. And what you see in those kinds of situations is that what we do not have is that trust relation. We come from far away, from a different cultural, sociological background, and trying to really communicate and really talk about the most horrific acts that a man can see, mankind can see. That's something that we will never be able to provide with our own detectives. Surely they're well trained and qualified and what have you, but that is something that an NGO is really the additional value, if you would ask me.
Yeah, no, and I think it is happening, you know, with the some NGOs who work a lot with prosecutors. They do accompany victims. They would not take statements, but they will accompany them to provide the context, but they would not be the ones taking the statements, obviously to avoid discreditation of witnesses eventually. Thomas, did you want to add something on the role of civil society actors and their role in success or otherwise of the cases?
Yes, thank you. I definitely identify myself with Jeroen, what just Jeroen said. And let me give you two concrete examples with regards to this case, to the Rohingya case here in Argentina. So the first thing is that as soon as the complaint was filed at the court, huge number of civil society organizations approached us, trying to help, trying to say here we are, and that's fantastic, and we welcome all support. But at the same time, it has been incredible time-consuming for us. It's like how would you respond to to so many civil society organizations ready to help, but at the end of the day, it's you that need to let them know how to help you. It's quite stressful, let me tell you, and quite time-consuming. I think that it's need to reevaluate how the NGOs could really, have a role in litigation, because, for example, on the issue of witnesses, and this is a problem that we have. Okay, do we have a list of witnesses? Do you have a list of witnesses that we can, as Jeroen said, we can approach them and see if they are witnesses for the case? Well, that question has not been responded, because either they don't have, there is no list, or there is a list, but there is, the requirement of the consent of the victim to be used in a court of law as a witness, and then there is a problem there because they might not give you the list if they do not get the consent from the victim. And this is an issue that also came up with the Enablement, the Myanmar mechanism of the United Nations. When we reach out to them and we encourage them to talk to the Argentinian court, and we said them, please, start engaging with the Argentinian court, because there is a real case now, the investigation is being launched, so you have to engage. And finally, they started to engage with them, and actually they visited Buenos Aires. The Myanmar mechanism visited Buenos Aires, and they met the judge, and they started engaging. And that's fantastic, because it means that what is in theory, it's becoming real, that the UN mechanism is engaging with the Universal Jurisdiction Court. Now, they have the same problem. When we ask the list of victims to the mechanism, they say, we don't have, a list of victims that that you can use as witnesses in your case, because we need to, overcome basically the consent process, from the victim. So there's a huge problem there in this respect. And so this is one issue. Of course, we welcome and we are open to everybody. And the case, this case in Argentina is not just, it's not a case of just one organization, civil society organization. Everyone can come here, because, we are talking about the plight of the Rohingya. Although the organization who filed the complaint, it's a Rohingya organization themselves. It's an organization integrated by Rohingya people. That's also an interesting element. But the second thing that I wanted to also share with you, which has been a problem, and I want to be basically direct with you, we had an organization. Every time that an organization wants to work with us in this case, we say, okay, let's coordinate, let's work together, let's build trust, because the case here in Argentina is still fragile, and has been fragile in terms of getting the decisions from the appeal court to open the investigation. Has been a very fragile process. So, we need coordination with the civil society organization, and good coordination. Because what happened is that we had an organization that pretended to, they decided to present an amicus brief, for example. And then we say, okay, that's great. Everyone who wants to present an amicus brief, you are welcome. Let's get some information from you, and it's important that you know better about the case, because then your amicus brief will be successful. So what happened is that one of the organizations decided to just do it on their own, and it was a problem for us in the midst of the discussion about whether or not we needed to open the investigation and universal jurisdiction was acceptable. And actually, that amicus brief was dismissed by the court, So it's not a good sign to have a dismissal of an amicus brief from an international NGO. And that happened because it was a lack of coordination. And now this international NGO continues to, try to get into the case without really knowing what's happening, and it's bringing real trouble for the sake of effectiveness of the case. So, I stop here, but I think there is a lot to do with respect to the engagement, at least in Argentina, the engagement between the civil society organization and how litigation could be, could count on the work of the civil society organizations.
Thank you very much, Thomas. I would just add one line and then move to another question. I think there is also now a very big difference, because the NGO community is much less homogeneous than it used to be. And I think there are organizations, many of whom are present here, like ICCHR, Trial International, FIDH, the Docket, who were kind of conceived with the idea of working with state authorities with prosecutorials. And then there are other excellent NGOs for whom it's not their main purpose. And yet, so they don't care in some ways whether, their evidence will be, or the information that they collect will be admissible. They collect it nonetheless. And then, the reports might be used again, but they go and they interview witnesses and they collect documents and they put them in the public reporting. I think it's just this just has to be taken into account, and ultimately does come to trust between the players on all ends. And, there is nothing we can do about it. It's just the reality of the kind of NGO ecosystem. But I do think it's important, like when we talk about civil society actors in general, it's not, a very homogeneous field. I would later on welcome some comments. I'm sure many people in this room have a lot to say on that, but I did want to circle back to one of the themes that kind of appeared on the first day and was developed further this morning, which Karim Khan called, the common front of legality, which I liked as a phrase. It's another way of talking about the universality of international justice. And so my question goes back to how do we create this common front of legality? I think it's the question now with Ukraine becomes very, very interesting, because there are already, as we all discussed, many different processes being set up, and I'll go back to that in my next question a little bit. But for now, it's really the question of all of these countries that at least allegedly have universal jurisdiction provisions to a certain extent. I would very much like to ask the distinguished audience and panelists if they know whether it's really 169 countries or more at this stage. I keep quoting this figure from Amnesty report from like about 10 years ago. We're now actually checking it, but if somebody has already checked, I would be very grateful for your insights. But how do we make sure that other regions, as was discussed in other panels, take the lead, create networks that are similar to Eurojust? Is there a room there for Interjust, just using the Europol and Interpol analogy? Is there a role there for Interjust? And how, in practical terms, we can create this common front of legality?
That's a big one, but I can, and I think I'm going to still be thinking about it later as well. But one thing that for me as a historian is also a really big question, and it ties to what you were just saying, is what is different now from all these other situations where we had all of these initiatives within like, boom, a week. So as a historian and also someone who working in this field is a good thing to think about. Why in Ukraine, and what factors can be replicated potentially in other contexts to get, attention, funding, and all these other requirements. So I am afraid I don't have anything better to say, because it's really a massive challenge, I think, to try to maybe not replicate, but to have the same kind of engagement, attention, funding, and all of this when it comes to many other situations that require it. I wish I had the answer.
You mean replicating it without one of the world's largest nuclear power attacking a neighboring country?
Yes, that's exactly what I meant, yes.
There are many thoughts that go through my mind, and one of them also relates to what Uiso mentioned. Somehow getting the universal jurisdiction cases also to the areas, the regions where the crimes took place, preferably in the state itself, if not in neighboring states. I really see that as well as something that, to some degree, by the lack of it, let me put it the other way around. If I have to make decisions on which cases we need to investigate and prosecute, the first question that we ask ourselves, is there a other country better in place to provide this piece of justice? And if that's the case, what we usually run into in discussions with, for instance, our Ministry of Justice or Foreign Affairs, is that I would like to see an individual be extradited but not having yet an extradition request. Can I contact this state and say, you're interested, you're looking into the specific region, I would like to help you. We've got a possible suspect on our territory. And rather than putting resources, which I will do eventually, because a case must be tried, and the Netherlands and any other state cannot be safe haven, preferably I would like to receive an extradition request. And the answer that I get is that I'm too practical and that there are specific legal aspects that I need to take into consideration. Of course, I'm a trial lawyer, I understand that, but somehow I find it very difficult to understand that somehow we cannot inform this other state that an individual might be of interest to them, and with an extradition request within 2 years, usually these procedures take that long, and if the case is strong enough, a person might be extradited to a state, which obviously that's also prerequisite as a rule of law, but that's something that's plain and simple. So those things that's what we run into occasionally within our own practice. And the other thing is that what the question of Matthäus was, is something that I also see. We need to help other regions and beginning small, as we also mentioned, begin small with those countries. So I already noted, for instance, Bangladesh and Kenya. Without the knowledge of whom to contact and to provide advice and our lessons learned, we would be more than willing and would be very pleased to help others. Because what I also find striking is that there is almost prior it was my birthday, 24th of February, and after. There was hardly any interest or political will, motivation. Hardly, there was some obviously, but it's completely different at the moment. And it's a European issue with obviously one of the superpowers that is involved, Ukraine and Russia. But somehow I feel a bit of unease, because there are many other situations that we are looking into. And within our own policy in my office, we decided to stipulate that it is our duty to make sure that we have a balanced and equal attention focus for the investigation and prosecutions of all conflicts that might end up in our jurisdiction. So those were my thoughts. Not exactly an answer, probably, but it was a big question.
No, but it is a difficult question. I think we'll hopefully beyond this conference we'll continue to discuss it. I do think that it might be, one of the very helpful outcomes. I think speaking of neighboring countries, it is very interesting to see, Poland and Latvia already opening investigation. I don't think either country had any UJ cases before, if I'm not mistaken. So it would be very interesting to see the same happening in other regions of the world. But at least, we already have not just Western Europe, but at least True. Eastern Europe on board, and I think there'll be more. Lithuania, I think, is a likely candidate potentially. But Thomas, what about in Latin America? Do you see there is any appetite? Because Argentina has obviously been in the forefront of universal jurisdiction in many ways, but there are definitely other countries that at least have the possibility. Do you feel that there is any desire and any opportunity to create some kind of unity, or just to initiate cases in other countries as well?
Yeah, well, I'm not really well aware about the overall situation in Latin America, but I'm not sure if there is an appetite, to be honest. But we do have, I think, the legal basis. I think the constitutional basis in our region. We have the Inter-American System of Human Rights with the Inter-American Commission and the Inter-American Court of Human Rights with very well developed jurisprudence in international human rights law, but also in some cases international criminal law. We have our own basically experience dealing with dramatic human rights abuses in the past. And each country in Latin America dealt with the past in different ways. But it's a very interesting experience that we have in terms of seeking justice, pursuing truth, so what I'm saying is that there are a number of factors there in Latin America that may allow to further strengthen or explore national jurisdiction for international crimes. And basically, this case in Argentina also, I mean, while of course the main goal is seeking justice for the Rohingya, we are always very well conscious that we want to strengthen the principle of universal jurisdiction in this particular case. That's we are very careful in each step that we are taking because we don't want to undermine the principle itself. And we know that this may not be the ideal region, as Joanne was saying, to pursue a case of a crime committed in the other part of the planet. And we are aware about it because we are facing the constraints, you know. We were speaking today about the issue of language. I mean, in the case of the Rohingyas, we have, for example, in terms of interpretation, we have double interpretation because you have to translate from the Rohingya or Burmese language to English and then from English to Spanish. So we are really facing all these very, very specific, concrete, you know, problems in terms of how to carry out the investigation. But we are confident that we will, you know, we will do that, and we will. We expect that the court, you know, at the beginning the court was also reluctant about all these constraints, and then they decided, okay, we will do it. But I'm saying, but even beyond all those particularities of this case in this region in Latin America, basically we want to strengthen and we want to raise the importance of universal jurisdiction in Latin America. I mean, the door is open to basically start working on that. Let me put it like this, and I think that the NGO community, civil society organizations have an interesting, you know, space to work on this issue. And also it is interesting that, I mean, this is a very basic idea that, but usually used, that we are in the south part of the planet, you know, sometimes that means that we can identify ourselves with some other countries in the south part of the planet, and so we think that that also gives to the exercise of universal jurisdiction, you know, good arguments, you know, in terms of it's not superpowers, it's not, you know, oppressing developing countries. We are equal states, and we are just complying with what is provided at the international level, which is universal jurisdiction.
Thank you, Thomas. And I couldn't agree more. And as some of the people in this audience know, I've been pitching from the moment, for example, when the Ukraine conflict started, this idea that ideally we would see UJ cases beyond Europe. Because symbolic, in addition to practical reasons for that, you know, there is also this symbolism of it's not just being a Western condemnation, be it, you know, European and Canadian, of big ugly Russia, but that it is a truly universal condemnation of the crimes that are being committed. But let me just ask one last question, which I think is important in relation to Ukraine, which I'm sorry we kept coming back to, but it is on everybody's mind and it's very difficult to move away from it. But I do think that this situation also raises some very big issues that we would need to be looking into as practitioners, as academics, as NGO community in the years to come in relation to international justice. And that is, we have this unique situation, as Eva was very helpfully describing, of that we haven't seen, quite quite frankly, in any other conflict of the last decades, where we have a very active national investigation. The Prosecutor General of Ukraine has already opened more than 10,000 cases, and moving very fast with that. We have Icc Investigation, which opened very, very quickly. We obviously have already quite a few investigations, extraterritorial, UJ, in a number of European jurisdictions plus Canada. And we also, just to kind of on the side note, we have the UN Commission of Inquiry, we have the OSCE Moscow mechanism, we have the decision by International Court of Justice, and we have the decision of International Court of Human Rights, and so on and so forth. So how does it all work together? Yeah. What are some of the advantages? What are some of the challenges? What would it look like a few years down the line when it comes to potentially apprehending the perpetrators? Is it helpful? Is it not helpful? I know it's a big question, but I thus invite both general and very practical comments as you wish.
Maybe I'll start. For some reason, I keep going in the
yeah, I keep
order.
going in order. I need to mix it up a little bit, but
it's a really good question, and I think what I was saying also in my comments about this idea that it's really a long-term commitment. So it's going to be interesting to see how much of it is sustained through time. And how much of it drops away, because of course a lot of this, I think, also coming back to the comments on the civil society, I think, of course, to a certain extent, civil society, and organizations do what they want to do, but I think to a certain extent it's also donor-driven. And we've seen that also in Bosnia and Herzegovina as well, that there's certain things that, they're funding it, we're going to do that as well. So I think donors can have a big say in kind of how some of these things play out, and how long the commitment will last. But I just want to say a practical thing as a former Yugoslav myself, and someone who worked as a practitioner in war crimes cases. When I came to The Hague, and this was in the late 2000s, and for years before, I think for many years no one believed that, for example, Karadzic and Mladic would ever be caught. It was just like, that's just not going to happen, and we maybe wouldn't say it publicly, but everyone was like, of course not, right? Because they've been fugitives for 15 years or something. And then they were. And then, so I also want to say to Ukrainians, to not lose hope in that regard, because it will take time. And as Ovisa was saying as well, I wrote an entire article about how time can be good. Time is not always bad. They came, when Karadzic and Mladic came, the prosecution, at least from my perspective, was like, hello, welcome, here's the case with a bow tie on it. Because they did so many cases before that. And it was like Alan Tiger and the crowd at the prosecutor at the ICT, I was like, hello, let's do this. So I think in some respects, this long-term kind of outlook and this sense of maybe it's not working now, but maybe in 10 years it will. And just to go back to the Karadzic and Mladic story, then when they did come, they was like, oh, they're so old, and Mladic was in a really bad shape. People thought they're not going to live, and then they did. And then there was an appeal, and that was finished too. And now they're both serving lifelong sentences. So I would say to anyone who gets depressed, and I get depressed about this stuff too, is to look at that case. No one thought it would happen, and then it did. So I would also kind of have this, long-term commitment, and it's like, even if in 2 or 3 years' time, we don't necessarily have a lot of convictions, that it's still worth going, right? And it's still worth investigating and trying to do a lot of these small level cases to build up. Otherwise, I think it's very difficult, if not impossible, to get high up people convicted if you've never done any small fry cases. So that's my wisdom.
I share your hope and optimism, especially as somebody who's been documenting the crimes of Russian regime for about 2 decades. I definitely am hoping to live to the moment. But it's also the question of the Karadzics and Mladics of Russia. That was my question, was about who gets them in the end, right? When we have so many parallel processes going. Joran, you don't have to answer this particular question. But
No. That's quite all right. I'm worried actually with all the investigations and all the organizations getting involved, and they do have the mandate, and they will obviously provide information and helpful documents, and perhaps even political mobilization with their work. What I do believe is that there's an obligation for us as professionals in the core international crimes arena to inform those that are so swept and carried away with the heinous crimes and the scale of it, and with all the videos that you can really follow the conflict day by day, is that this will take 30, 40 years. And people, institutions, organizations need to have the stamina, the will to be able to keep going, and the funding as well. And that's really critical. If not, many of those initiatives will, I don't have a glass, but they will fall apart or come to a stop. And in the end, it will be prosecution services that will remain, that are permanently funded. We just tried a Afghan case during the communist regime in the 80s. A colleague of mine had a conviction. This was a police officer in a correction in the Poli Chakri prison in Kabul, where there are a lot of people detained without any form of trial. And he was sentenced to 12 years, and this was in the 80s. We also have a case of the 70s in Ethiopia. So when I talk about CIC, I always say we run the marathon, and we've got stamina. And I hope you will have that too once you want to join us in this enterprise. And that's something that time will tell. I usually am optimistic, but with these amount of initiatives, some will definitely stop. And the coordination where Karim Khan keeps hammering on, and he rightly so. I don't see an answer for those many different initiatives to have that coordinated properly.
Thomas?
Yeah, I have a couple of observations on that, and it's great to be the last one, always responding questions. So the issue of witnesses, this is something that we are facing with our case, so many different bodies, whether it is a judicial body or, fact-finding or quasi-judicial or non-judicial, sometimes talking to the same witnesses, and the same witnesses, repeating the stories every time. This is, for example, in the case of North Korea, DDPR Korea, an issue, because you have, the same victims giving statements repeatedly, throughout the years. So that's an issue. That's an issue. How is that working? I don't know. And how would that work in the case of Ukraine? I don't know. The second issue is it is important to basically look into the mandate of each of these, bodies, and see what is the main goal. It is to halt ongoing abuses. It is to deter abuses in the future. It is, to get criminal prosecutions. It is to, build the truth and, a process of memorialization. What are their different mandates? Because I can speak about the United Nations. In the case of the Rohingyas, our complaint, our judicial complaint in Argentina mainly was based on the findings of the fact-finding mission of Myanmar. We used the fact-finding mission for that. So in that respect, it worked out very well, because the reliability and the credibility of the conclusions of the fact-finding was very useful to show the Argentinian court the seriousness of our allegations. So that's another issue. To look into the different mandates And then on the issue of time, one of the features that we argue in our case here in Argentina to the court and to the prosecutor is that we encourage them to move forward with the case because we told them this is an opportunity to start looking for justice contemporary to the commission of the crimes, because we filed in 2019, most of the crimes were committed in 2017 in Rakhine State. So it was very interesting to bring this argument, to have the chance to start a process of justice at the same time, basically, when the crimes were committed, because most of the examples, and at least in Latin America, in Argentina, in our own process of justice, trials took place many, many years after the crimes were committed.
Thank you all very much for trying to answer this very difficult question. I think there will be many more discussions going forward. I will now open it to the audience for any questions to our panelists, any reflections on some of the questions that we touched. Okay, Beth, I think you were first. Go ahead, please.
Sorry to take the microphone again. I would love to get the thoughts from the panel on how third states could assist second states in prosecuting cases arising out of a first state. And I'm thinking particularly of our own system where, as many will know, we have a very weak universal jurisdiction legal framework. So we often can't do these cases in our own courts. There are some proposals that are floating around the Hill now to rectify that, but that will only have prospective jurisdiction. But there is a lot of interest within the State Department in particular, but also I think our Department of Justice and FBI to assist with universal jurisdiction cases that are happening elsewhere. And so lots of ideas come to mind, information sharing, funding of NGOs that are working with victims, et cetera, but I would love to get views from the panel about what more we could be doing to help enable these cases that are happening in your courts.
Thank you very much. And what we're going to do here, I will just take hands from the panelists rather than going one by one. Johan, please go ahead.
Well, that's a somewhat difficult question because it requires looking at the work that we do the other way around. What came to my mind is as a third, we use third states in our investigations. And when do we use those? Because the witnesses or victims that we want to interview are unable to visit the Netherlands for security reasons. And third states might be a solution for their travel, not to raise attention, for them to blend in, for instance, an NGO who's able to arrange that when we don't have any diplomatic relations with the countries that these individuals are in place. So that's when we look at third states to assist mainly. So the other thoughts they didn't come to how do you say volwassenheid, maturity, unfortunately. So witnesses in third states, that's something that jumps to my mind. Yeah.
Did we lose Thomas? Thomas, are you still with us?
No, sorry, here I am, don't worry.
All right, you are with us. Oh, here we have you back. Sorry, the video just disappeared for a second. Any other responses?
I think Thomas.
Either of you. Thomas, please go ahead.
Yeah, it's a very good point. For example, in the case of the US, we really welcomed the declaration that genocide was committed against the Rohingya, and we actually requested the Argentinian court to reach out to the Department of State, asking, their reports and asking the Department of State their reasons that give base to that conclusion. So that's a very specific, maybe not critical example, but it is interesting because it gives, more, of course, support to the case itself if third states are involved. Another interesting way of getting the help of third states is the question of extradition. It was raised already. In the case of Myanmar, that will be an interesting question, how third states, especially Southeast Asian countries, where some of suspects might, travel, Southeast Asian countries or other countries, how would then respond to a request of extradition from Argentina? And this goes beyond the technical issue of whether or not there is extradition treaty on all these elements. But in a few words, the third countries with respect to extradition, it will be critical also in terms of how to help pursue justice under a universal jurisdiction case. And then Geraldine was talking about the trip of the traveling of witnesses. That's also an issue. In the case of the Rohingyas living in Cox's Bazar, we will need, since these people are not really recognized as refugees, we will need the Bangladesh authorization for them to leave the country. And we are now working on that issue, which is not easy. And the help and the contribution of third countries in this respect, engaging with the Bangladesh government on this, and making the point that it's very important that the government of Bangladesh lets these 6 women to leave the camp and travel to Argentina. It's also really an interesting point, and we will really welcome the help of third states in this respect.
Just a tiny intervention to Ambassador Van Schaak's question. I'm not a legal practitioner, so I'm not going to just be winging it. But what I want to say is that I think third countries and donor countries especially, something that can be done is fund human losses projects. I think it's really important to list who was a victim. And I think in Bosnia, it's one of really fundamental instrument in fighting denial. It doesn't sound so sexy. It's Excel sheets, and death certificates and things like that. But I think going forward, and also as a historian for kind of the establishment of facts, it's really a fundamental issue that I think donors could be contributing to significantly. Thank you.
Thank you. If I can just add one liner to this. I think also, if we're speaking about the United States, there's one question about the purely judicial prosecutorial cooperation by third states, but there is much, and U.S. may not be that great on universal jurisdiction, but they're great on sanctions or assets freezing, which could also be quite critical in this case, especially if we're talking about not just victims harm, but compensations and things like that. And also, I'm not going to open this kind of worms about the mutual legal assistance requests, but I hope at some point, maybe in some of the panels, we will address it, because it's just such a critical issue, and in my experience, they do not always work the way they should, and improving the system would be really helpful. I think Andreas had a question, so please go ahead.
Yeah, thank you very much, and I think and hope the question fits actually quite well in the discussion. So, what are success factors for core international crimes prosecution at national level? I mean, one success factor, I guess, is to get hold of the perpetrators. And I mean, I think in many universal jurisdiction cases, you see they're more based on opportunity, I would call them, because perpetrators happen to be somewhere mostly in Europe, so that brings then those cases to prosecution. But I think the question is also more how to get those that are not in Europe for whatever reason. Maybe they are sanctioned and can't travel, maybe they are still in power, maybe they are hiding elsewhere, maybe, for whatever reason. I mean, you had the ICTY, ICTR, ICC also mostly looking into the most responsibles in the conflict. But on universal jurisdiction, that doesn't happen that much. I mean, there are some examples where you have now, fortunately, also in Syria, arrest warrants against high-level perpetrators from some countries. And I know the Dutch, I think, can't even go that way, except you have a Dutch victim. Otherwise, you don't have jurisdiction even to get to arrest warrants. And then all the extradition and other questions kick in. But I think the question is more on universal jurisdiction. I mean, how do we get to more arrest warrants to get basically more strategically those persons mostly responsible for the commission of those crimes before national courts?
Thank you very much for the key question. How do we get them? Anybody wants to start? All right.
I would like to get them, for sure. I guess this is just a system flaw in international politics. That's to me the obvious reason, and also the solution. Being able to get that political pressure on. I believe that was also the reason why Karadzic and Mladic in the end were turned over to the court. So somehow there needs to be a mobilization of political will to get that done. But on the other hand, using international arrest warrants limits their movement, might end up in a lucky hit, so to speak. I fully agree, it is at random, and that's something that is also that gives you, on the prosecution side, also another feeling of unease that it should be equal to all, and those most responsible are actually the first that you would like to have before you in court. And the reality is that, as you mentioned, it's the other way around. The good thing, though, is, otherwise I seem very negative, and that's not, like I said, who I am. I'm quite positive. Is that given the stamina that you have in time, what we've seen in the Netherlands and other countries that have large movement of asylum seekers, in the end, usually you would have a regime change where the former regime leaders or those in place seek refuge, usually near wealthy states where there is a good living, a good way of life. And that's the reason why some of our middle level or even some high level individuals in the end came into view 20, 30 years or even 50 years after the crimes have committed. Now, we do understand that the public demands results now, sure. And this is something that we also need to explain, something like a shoplifting, that's something that you can arrange. We just spoke about the complexity also of these kind of investigations, as you are fully aware. This takes time. In addition, within your own country, you have the political wills already organized, and on international level, that will always lack, unfortunately.
If I may.
Please, Thomas, go ahead.
So let's don't forget that in any criminal case, the defendant or the suspect has the right to counsel, you know. So in the case here in Argentina, at any point, we don't know when it's going to happen, but you know, some attorney could present himself before the court or herself before the court and say, I'm, representing the interest of suspects, and we want access to the file, and we want to see what is the evidence, and so forth and so forth. At the end, this is a trial, and it's a litigation, and you have to prove your case. That's we are very well aware about that, and we are aware about what is it that an attorney of a defendant could do in a universal jurisdiction case? Basically attack the basis of that jurisdiction constantly. Try to kill the case. So we are very well aware about that. Fortunately, so far nobody appeared. But I mean, let me tell you, we are the victims are the ones who will decide what is they are going to ask the prosecutor, this designated prosecutor and designated judge, who to target. And we are now working on that, and we will perfectly decide to target the most responsible of the genocide of Rohingya. Then, of course, will be the decision of the court, but that has been the experience of the Argentinian process of justice, our own process of justice. We are the most responsible generals in our own dictatorship were brought to trial and convicted. So there is a reasoning there that the idea of targeting the most responsible would be the best case scenario. Of course, then you will have to face all the difficulties, including in the case now of Myanmar, of the immunity of head of state and so on and so forth. Those are another questions. So we understand the international arrest warrants will be a great achievement for the sake of justice in this case. Basically, because there is something that I haven't told you about the criminal procedure in Argentina. Trial in absentia is not allowed. If you don't have the perpetrator sitting at trial, that it's not going to happen. So we are conscious about this limitation, this concrete limitation, very specific concrete limitation. That's why we are prepared, and we are basically doing it using the whole process to basically feed the idea of seeking justice and bringing perpetrators to justice. And we will look forward for international arrest warrants. And the Argentinian case against the military perpetrators and all those who had a role in terms of complicity with the genocide, because for you to know, the complaint includes a long list of all those possible participants of the crime of genocide. But we got to know that the military in Myanmar distributed an instruction saying that they are concerned about both the case at the International Criminal Court and the case in Argentina. I don't know to what level they are concerned, but they instructed their officials not to respond to any request of information from each of these entities. So yes, this is what we have in mind in our case, basically, and we are discussing with the victims what is it that they want.
Thank you. I think we have time for maybe one last question. Please go ahead.
Thank you very much. I want to refer to the question of Ms. Eva, which was a question or a kind of a proposal for a common mechanism for testimony making and evidence collection to enhance the work of CSOs. Speaking of that, I would just like to speak about two factors that are challenging in case we want to address the matter of CSOs. The first one is political enablement. For example, some causes are not politically supported in most countries, such as what's happening in Yemen or what's happening from human rights violations against Palestinians. And this is a big contribution to having low skills within CSOs. And also another challenge I want to address is that for some CSOs, for example, in the Syrian context, the culture of CSOs in general is new, relatively new, especially with a regime that did not allow the establishment of CSOs. It was banned in Syria since the 70s. So we are new to the concept of freedom, let's just say, and this proposes several difficulties such as lack of funding, which also results in lack of human resources, and this also results in the lack of skills in testimony taking and all the other factors to build a case. And also we have the lack of coordination, as it was spoken about. And again, it's also because of having different funders that support different factors of the Syrian context. So I just wanted to highlight those several challenges that can make it difficult to have a common strategy for testimony taking or evidence collection. Thank you.
I just want to acknowledge the fact that I understand all of those things, and when I said certification, I absolutely have no idea how that would work in practice. But I just meant that I think there would be a good idea to think about. It's just something that occurred to me the other day talking to someone who was working in Ukraine, to start thinking if there is a stamp of some kind that can be introduced, some kind of process that could be introduced that can say we are a certified organization to do this kind of work, if this is something that indeed we want to do. And I think donors here would be crucial. To address a little bit what Jeroen was saying as well, this just difficulty of trying to figure out who to work with or not, especially when you're so far away. But thank you very much, very, very well noted.
And what would you do with all the journalists who are also doing documentation now? That's an increasingly, and citizen journalists and everybody else. I think it's a challenging thing. So we have a few minutes for closing remarks. Before we go into that, I would like to circle back just very briefly to what I mentioned when we're talking about this common front of legality, and maybe take the conversations to the corridors, but I would really like to speak to you all about I do think if we want to move this particularly UJ cases internationally, right, beyond Europe, we do need to have a mapping first. And that's what we're doing right now, but I really would like to know if anybody has already done that so that we don't duplicate it. So if you have done that, please let me know, but if not, it would be really great to combine resources on that. It's not a huge project, but I think it will be very helpful when we're trying to understand at least which countries have it, so that we can start somewhere with how to work on that. And on that note, just for the just a few minutes of closing remarks, I think I will circle back to the question: what are the success factors? And ask you a more general question: are we in the state of success? Can we rest on our successes, or is there still work to do? Kind of an obvious question, but nonetheless. I'll change the order now. I'll change the order and go to Thomas first.
Oh, okay. Okay. I didn't know it's going to be like that at the end anyway. No, it's all right.
You don't have to be guided to my question. If there are certain things, it's just the closing remarks. So if there are certain things that we should have asked you but haven't, please, the floor is yours.
No,
for just a few minutes.
I think that the mapping it's incredibly important. We know that there is some information out there about it, but a more consistent analysis of how universal jurisdiction is currently being used around the world will be very helpful. For us, will be very helpful. As I told you before, I'm not quite very well aware about the situation in Latin America. There are some countries have used, but I don't have a complete picture of about it. And on your last point, which is, I mean, it's we see a great evolution in international criminal law, international human rights law, the national framework for prosecutions for international criminal law. We see the very important growing of the civil society community with a lot of expertise. So we should be, you know, I would say, glad about this this kind of evolution. But at the same time, you know, we human beings, we are still, you know, committing the most serious atrocities. It's unbelievable. But it continues. So the struggle continues, and the struggle continues. And our belief that the sake of justice, it's one critical element, basically, to ratify our convictions about human rights values, about the values of the United Nations Charter, peace, security, and human rights. The instrument of the justice system is critical. This is at least what I perceive as someone who comes from the legal frameworks and as an attorney. but also with experience in the international arena and the diplomatic arena. I believe that the facing the challenges of pursue justice and saying the truth about atrocities, it is key, to hope that in the future the level of violence that we human beings sometimes applied among us will, reduced. And this is a kind of, political statement, but I would just say that we are very committed to this Rohingya universal jurisdiction case. We hope that it will move fast, and we are looking for concrete achievements in the near future for the Rohingyas themselves, because we believe that the Rohingyas deserve our utmost efforts.
Thank you so much. Thank you. Justice.
Yeah, just a short point that I'm personally going to take away from this discussion, also the previous discussion, and that brings me back to the comment Wiso made, that I've come to believe that we are within the Netherlands in such a good position that it also comes with the obligation to help other regions assist in our knowledge and advice to be able to provide those regions the best ability to also investigate and prosecute core international crimes, so that universal jurisdiction is truly universal, not just a European mainly, and of course also Latin America enterprise, because it's not. So that's something that I take away, also including the remark that Matthäus already mentioned. Thank you.
Thanks a lot.
And now in 90 seconds, because I think everyone is already quite keen to get some coffee, I want to circle back to the word that Jeroen used, which is stamina. And I think this idea of a long-term commitment and having in mind these really, the idea that it's going to take a long time to deal with the crimes coming out of Ukraine, but also, of course, elsewhere, and to go back to our expectations. I feel like we often discuss very practical matters, but it seems to me that it is worthwhile trying to step back and figure out what the benchmarks are and what do we think constitutes success and what do we think constitutes failure for UJ cases, but also otherwise, to try to really then focus, okay, this is what success is. Of course, it's not going to be a consensus, but to try to flesh it out in more detail than to kind of be reactive, constantly talking about just every single sort of conflict that happens. So I would like to see that kind of engagement with the idea of this is success, this is failure, and now this is how we can work towards what we think works, right? So thank you.
Thank you all very much, and thank you for keeping to the time. I would also thank you very much, Eva, Joren, and Thomas, for your insightful comments, and thank you for the audience. It's always difficult. The panel after lunch is the hardest one, I feel, but thank you for your engagement, for staying with us and not falling asleep, and for your insightful questions. I'm sure there'll be some of these themes will be picked up by other speakers in the following panels. Thank you.
Thank you.